All right. Any other quick matters, setovers, strikes?
I was going to see if we could do a continuance for Anderson and Erickson. I was late serving because I'm not represented. And I had to get help through Northwest Justice, the women's shelter, along with having a baby and my toddler. I was late and I feel really bad about that. I wasn't sure how to ask.
That's okay. Ms. Winkles, I see you here this afternoon. You're representing Mr. Anderson in this matter.
Yes, Your Honor, and I would ask that it not be continued. Ms. Erickson, we have, between my client, he has separate cases with her as well. She was able to file a petition in those cases, which meant she chose to do that rather than answer these. So she's self-represented in both and chose to put in 20 pages into one and none in the other. I would ask that this go forward today. She's had plenty of time. We actually gave additional time. We've been here before. We're here on a motion to compel next week. We were here last week. At some point, the delays need to stop. So I ask that we go forward. I don't mind if she argues something that's not written down. I would just rather get a temporary parenting plan. My client hasn't seen his child since she was born. The GAL report is in. So I don't think there's anything that limits us, especially if she's able to.
All right. Any response to that, Ms. Erickson?
I have a lot to say to that, but I'm not sure if it would be appropriate or not. But the whole motion to compel thing was on because of her behalf, because she didn't send me the right paperwork. So I wasn't saying that I was supposed to call. It said the petitioner was supposed to call, and it wasn't me. So that really wasn't on me. But I was just trying to be nice for the other side to read what I had sent. I'm not being represented. I wish I could be. I've been looking. I don't have the money to do it. I have 2 kids at home all by myself. I've been trying to get everything done that I can, and I try to get it all turned in on Friday. I'm very sorry, and I'm not coming up with excuses or anything. I'm being honest.
All right. I understand both sides and wanting some resolution. We are on for next week, the 9th. I'm going to add this onto the 9th. So I'm going to give you 1 week to submit something. If you don't have anything submitted, then we're going to move forward.
Well, I'm
talking. Don't interrupt me when I'm talking.
Sorry.
Okay, Ms. Erickson, that's not a good way to start off here. So if you submit something, great. If you don't, we're moving forward regardless. Is that fair?
Yes, I'm sorry.
All right. We'll see you on the 9th at 1:00.
Thank you.
Thank you.
Judge, Ms. McLean and I, number 18, Henry and DeHaan. I don't think it's a quick case, but it's not a long case, and I'll be super quick, but
okay.
It is. And for the record, I represent the petitioner the respondent moving party to the motion before you today, namely Esty DeHaan. We're here largely asking for some financial relief. It appears the parties are relatively close on what's to happen with the real property in Longview and listing that for sale through Remax and Eric Pucci. I think everybody's agreed with that. My client simply asking to remain in the home for a couple of more weeks to get her belongings out. We're agreeable to the suggestion that Mr. Henry then kind of bring in his friends or his acquaintances to kind of clear out his stuff and get that listed. The sooner the better, given the market is changing and the summer season is quickly approaching. That leads to the second part of the motion, which again centers around my client's request for spousal support. Now, this is a marriage of 13 years. The parties were married back on December 20th of 2008, separated in October of 2021. Which is where we come up with the 13 years. If you add on the fact that they were committed to each other since 2003, that stretches things out to roughly 18-year partnership between the two of them. My client details for you, and it's rebutted in Mr. Henry's pleadings about these physical conditions that she's had and that she struggles with on a daily basis. We've given you information from providers as well as herself, which shows that she has a chronic migraine condition in which she suffers debilitating migraine headaches to the point of blackouts several times per month. Despite that, she has recently, and I guess this is the good news, acquired some part-time employment through a bank up north in Lewis County. She'll be making $22.02 per hour, working 25 hours per week. We've given you proof of that contract through the bank at Twinstar as part of our reply declaration, reply pleadings. What we're asking for today is spousal support. It seems somewhat disingenuous when Mr. Henry, who is making in excess of, originally we thought 110,000, it appears he's making far in excess of that with his most recent pay stub that he provided under sealed. But nonetheless, he's been the breadwinner traditionally in this relationship, continues to, and he has the luxury now of living with an adult roommate in Hawaii on a beach, making significantly more money than my client will be able to and not provide any form of support. I'd rather suggest that she lives in an RV. Again, the RV, we've given you information about the functionality of that, the fact that that is now in desperate need of a roof, in desperate need of a generator, has significant issues. The suggestion from Mr. Henry is simply that my client move out of the house, they sell it and move in on some bare land property in Lewis County without any kind of connections for water or sewage or the like. And we again think that's highly unreasonable. We think that's highly unjust. My client should be able to get into an apartment or at least a lease, some kind of a suitable facility where she can live comfortably with her animals in. And the suggestion from Mr. Henry appears to be too bad. I'll hold on to the money. I'll live on the beach in Hawaii. Drink in excess and eat in excess of $1,500 per month in kind of luxury spending items. While my client's living in an RV where the roof is quite literally about ready to cave in. Repairs on that RV are in excess of $10,000. And again, she should be able to have some kind of a capacity to live in a suitable environment for her, close to her employment, which we think is an apartment of some sort. That leads to kind of the crux of the argument. Now, what's it going to take for her to get in? If you look at what she's earning currently and you take her $22.02 per hour times 25, that puts you just north of $2,000 per month gross, which is going to leave her with a net of about $1,800. Granted, and there's some dispute about what is in these accounts. Those are going to be issues that we're going to need to sort through on discovery on a final basis. I don't think temporary orders is the time to do that. That needs to be an issue that's resolved later. But my client needs some sort of access to funds enabling her to get into the apartment. Again, we provided you information which shows that her earnings, which does count support and alimony and the like, needs to be roughly 3 times what the rent is. We provided you information that shows the rent is $1,200, and she doesn't even qualify to turn the application in unless she has some sort of income, which in this case would be from her wages at Twin Star, in addition to whatever the court deems appropriate by way of maintenance. This is a long-term marriage or approaching a long-term marriage by statute. My client certainly has a need. Mr. certainly has an ability to pay. We believe that some kind of offset to equalize these incomes, again, is appropriate given the circumstances of this. We're asking for $1,500 per month in spousal support. Finally, and along those same lines, we are asking for a contribution in temporary attorney's fees and costs. And we have suggested the amount of $2,500. If the court is inclined to award some kind of temporary assistance on the legal costs and offset those, we're asking that anything you order be paid within 90 days of entry of the orders.
All right, thank you. Ms. McLean.
Thank you, may it please the court. I represent the petitioner, Barry Henry Jr., and I would ask that the court not consider or else give no weight to the unsworn declaration that was submitted by Katie Johnson. Clearly, it's not a medical record. It doesn't qualify as a medical record. It is a declaration and is unsworn. In addition, I would note that the most recent documentation submitted in response by Ms. DeHaan now has this sort of medical record or a graph where she keeps track supposedly of her symptomology and whatnot. And again, there's limited information. It's clear that she doesn't even follow the directions or the instructions on that document and provides limited to no information, suggesting that she's incapable of employment. I would also note that Ms. DeHaan doesn't deny that there was an independent migraine expert who testified at her Social Security disability examination and determined that she was fully capable of employment and that she was not successful in her Social Security disability claim. She makes absolutely no comments about that information, and we should assume now that she has been able to secure employment that she certainly is capable of employment. In my review of the documentation of her employment with Twin Star, while it does say part-time, it also does say that if she works more than 40 hours, she's going to be paid overtime as is required. There's nothing in that document that indicates that her part-time is limited to 25 hours or exactly what all is involved in that position. And of course, $22.02 is apparently her starting wage. She has substantial history, albeit about 8 years removed, having worked in the banking industry, earning a significant income. In addition, she doesn't deny that she also has this art business where she has sold art in the past. She's also driven for Uber and Lyft and DoorDash and makes additional income on the side that she's not reported to the court. But clearly, you can see at least the business income from 2020 and 2021 that are identified in the tax returns. For purposes of 2022 taxes, she was not forthcoming with any business documentation, but we did get her 1099s for her Lyft and other employment. I agree that this is a 13-year marriage. I disagree that the court should take into consideration any partnership timeframe for purposes of spousal maintenance. And statutes and case law are clear that individuals who are not married, are not able to make a request for spousal maintenance. So that's not properly before the court as far as determining just on a time period whether or not she should qualify for something more than a 13-year marriage. But she's 39 years old. She is capable of employment. She has many more years of employment before her. And you also saw that she identified to Mr. Price that she was applying for a meatpacking job, which the assumption is that would have been full-time. There's nothing that indicates she can't obtain secondary employment or continue her business on the side, or else these other employment opportunities through Lyft and Uber. So our position is that the court, if anything, should impute income to her at the level that we had suggested, which was based upon her prior earnings. That would put her at a net of $4,748 per month. If you use the current stated claim of $22.02 an hour, that would provide her full-time with a net of $3,222 per month. It's our position that she is capable of meeting her own needs. My client points out to you that her financial declaration is significantly padded. First off, she claims that she has a $400 per month health insurance expense. However, she doesn't pay to cover herself on health insurance. In fact, it's my client who is paying to cover her on his health insurance. She also pads utilities. She makes a claim that rent is going to be $2,275 per month. And yet she told my client that she had a rental for $900 that would take her animals, and produces no information in response to that in her reply declaration. She does submit documentation from a rental agency and suggests that while she has to have so long of a period of employment, it also identifies having a co-signer. There's nothing that suggests that her parents couldn't co-sign for her, but there are other private rentals that she could surely access and rent for a much more reasonable rental rate than she's proposing. This is designed to make herself appear that she actually has a need when in fact she doesn't if she applies herself. So our position is that, quite frankly, she had told my client that, I'm sorry?
I think that was a recent addition to the.
Oh, okay. I'm sorry. It's our understanding that she plans on either living with her boyfriend or taking the RV down to her folks' house. That was another suggestion. Now that she's got this job in Chehalis where her boyfriend lives, the assumption is that she's living with him. So not really certain what her financial arrangement would be with the boyfriend as far as sharing rent and whatnot. As it relates to this most recent billing or bid, as I would call it, on the RV repairs, my client already told you that he paid, I think it was almost $900 for necessary repairs to the motorhome. There was nothing that suggested that this motorhome needed a new rubber roof lining, that there was anything wrong with the rubber roofing. And you'll note that the bid that they received from Wheelers, which is the same facility that performed the repairs earlier this year, that bid is dated a day before she signed her reply declaration. So again, we just think that this is a red herring to suggest that she doesn't have suitable housing with that RV when that's been the plan all along, and they've already done the necessary repairs for that to be an appropriate place for her to live at a very reasonable price within her current needs. Essentially what Ms. DeHaan is asking is that my client support 3 different households, his own, of which he's living in a 600 square foot apartment, sharing expenses. He's currently paying for the house mortgage, the RV monthly payment, her insurance, and then monthly credit cards that were community credit cards. At the time, and actually it was after these folks separated, in August of 2022, Ms. DeHaan goes in and sweeps accounts. And if you look at the Fiber Federal Credit Union statement that we filed under seal, as of 3 months ago, she had $61,000 sitting in her savings account. Compare that with the $18,000 that she left to my client, of which he has been using those monies to supplement his earnings in order to pay all of these bills. The household bills where she's currently living so that this house can get marketed and sold, his own living expenses, he has already blown through his savings with the $18,000 that he had trying to supplement and pay all of these things. The suggestion that my client is earning $120,000 again is not borne out by the evidence. My client is earning his same hourly wage as he was last year. He earned almost $107,000 last year. And again, his net income right now is about $6,800 per month. So he's in the position where he's having to rob Peter to pay Paul. While again, Ms. DeHaan is sitting on $61,000 where she can supplement her own living expenses. She can pay her own attorney. So again, if you look at the realities, she has the means, she has the ability. This is not a spousal maintenance case. This is not an attorney's fees case. We had proposed that she be out of the house by May 15th. That's what's in my proposed order. We are asking that the court ordered her to be out of the house by May 15th. I didn't hear any objections to the other language that I had proposed in my proposed order as far as arranging for the balance of the other items to be removed from the home for my client to be able to obtain the balance of his items. We are asking that from escrow, assuming we get an offer in a relatively quick time, that from escrow, obviously they're going to pay the home mortgage and whatever else is related to the house. We're asking that from those sale proceeds that the motorhome be paid off, because that's going to relieve my client of a monthly payment of, I think it was $400 and some a month, as well as reimburse him for the Capital One debt that he has paid of the $8,001, because it was just coming off of the 0 interest. So he used, again, savings in order to pay that. That is a community debt. As you can see from the statement that we provided, the most recent charge on that debt was by Ms. DeHaan for her Comcast expense. And then we're proposing that each party receive $25,000 so that they both have some liquidity to float through until we're able to get this thing either resolved or through trial. Finally, we're asking, and apparently it's agreed that they'll split up their cell phone bills. My client was unaware that she had her own cell phone bill. So here he is paying an unnecessary bill because of the lack of her communication. That just, again, gives you insight into, my client's efforts at making positive movement forward and working in the best interest of the community, and Ms. DeHaan wasting assets. So we're asking that the court adopt our proposed orders and provide for the relief that we've requested.
Thank you. Mr. Zandy, any response?
So just briefly, if you look at the earnings statement that was provided by Mr. Henry under seal, he's made gross year-to-date income through February 10th of 2023 of $18,573. And again, that's that money based over a month and a half. So to assume that he's making more money now than he was, again, is completely appropriate. And that's information that was submitted by counsel on Mr. Henry's behalf. So he's certainly making far above what my client is. As far as these conditions, and again, I didn't belabor that point because it's largely moot. My client is working part-time. She's working up to 25 hours per week. She details that for you. It's in the employment contract. We'll see how that goes. By no means am I confident or is she confident that's going to be something that she's going to be able to persist in. But again, given the dire financial circumstances she has, that's the best she can do. And that's probably all she can do at this point. And that's being optimistic. We look at wasting materials and such, again, that's just red herrings. I mean, that's nothing that's been confirmed or validated through any of the pleadings. Both parties can make that assumption about the other one. And again, that's really not relevant to what the issues are before you today, which is simply financial relief for my client. Where these people go long-term is for another day. Once we exchange the discovery, once we get to a mediation or a trial, we can sort through all of those issues. But to assume, as Mr. Henry is trying to do, that this divorce can be resolved on a temporary basis, again, is inappropriate. What do we know? We know he's living in Hawaii, whether it's a 600-foot apartment or not, right off the beach with his new girlfriend, and again, sharing expenses. We know he makes in far excess of wages what my client does. We know that my client, for at least on a temporary basis, is going to be living in an RV that needs a new roof that probably won't make it through the winter. Regardless of the timing, that's the quote from Watkins. That's where it comes down at. And they have no reason to embellish or lie about the roof and the condition of the RV. Contrary to counsel statements, Mr. has paid a little bit over $700, $735 for the routine maintenance on the RV, and then just wants you to assume that he's taking care of it all. Again, that's not borne out by the facts, the own information that he's filed on his behalf. Looking at the years of employment, again, my client hasn't worked in 8 years. They moved from Arizona so that they could follow Mr. Henry's career path, the career path that he's chosen. My client doesn't have anybody up here. She has no connections to Washington State. She comes here based on the job opportunity of her husband, who's now working from home in Hawaii. It's somewhat concerning in the arguments that she just simply lived with her mom and dad. Again, her father is deceased. Living with that individual, I think, is going to be extremely difficult given the circumstances. That's not applicable. And I don't think that he can clearly co-sign on her behalf for any kind of lease on an apartment. Again, that's impractical. She was with a man for 18 years of her life. They moved from Arizona to Washington. And for him to say, well, essentially, I want to be off the hook for this and pursue my new life and my new girlfriend that I met on Tinder, again, seems grossly inequitable and grossly unfair. what we requested is appropriate. My client should be able to live in an apartment, and that 600-foot apartment on the beach in Hawaii, again, is certainly magnified when you look at what my client is being asked to live in, which is an old RV on a vacant land in Lewis County with no hookups, with somebody who is a friend and not a boyfriend. Again, that's just seems grossly inequitable. We are asking that you grant the relief as we requested.
Does she have access to $61,000 in a savings account?
It's 40,000, which is that money from dad's inheritance. That's the money that she tells you was put into the, he was added as a co-signer to that when she started having the medical issues years ago. My understanding is dad died around 2014. I'm not positive on that. I can get the date. And that money has essentially sat there since, with the understanding that was going to be her nest egg for retirement or such, not knowing what the outcome of the Social Security Administration was going to be.
Your Honor, that information is disputed. And if you take a look at the sealed financial source documents at page 43 that we filed, you'll see that as of February 28th, she had $61,040.80 in her personal savings and $116.25 in her personal checking. And that's just one account. I think there's two other accounts. There's a Chase account, although that the community Chase account might now be closed. And then I think that there were two community accounts. So, but as of February, she had a little over $61,000 sitting in savings.
And I don't know. And again, without going through full discovery, that's the hard part about doing this on a temporary basis. We don't know what's gone where. These people have been separated since 2021 when he moved, and they've sorted a lot of this out. It's akin to the Capital One card. He's had access to that. She's not even a signer on it. She can't log in or see what his purchases are. So you're back kind of in that same boat. And again, I think those are all issues that are going to need to be borne out through discovery. She does have a chunk of money. That's dad's inheritance, though.
And again, that's disputed.
All right. So I'm showing $452 a month is the payment for the motorhome. We agree on that.
That sounds about right. Yeah.
Yes, $452, and then the mortgage is $2,274.14.
All right.
Which hopefully will go away here real soon.
All right. So as far as Miss McLean's temporary family law order, the move out date, what's going to happen with the money? I didn't really hear a lot of concerns regarding that. And I reviewed it, so I'm going to sign off on that order. I do see a disparity. I think there's not going to say, I will say padding because I don't know what else, how else to say it, but padding going on in both financial declarations. Mr.'s financial declaration, he has $2,000 a month just in food and household expenses for one person. I understand Hawaii may be more expensive, but that's pretty excessive. And she did seek employment. She is now employed. Yesterday was her first day. It is part-time. What I'm going to do is on a very temporary basis, I'm going to order, because he is paying the $452 for the motorhome. And so I'm essentially going to take that off the top. So it doesn't, so that can just continue to happen until the house is paid off. I am going to order $600 a month spousal maintenance for 6 months. And then we'll review. I'm not going to order any attorney's fees at this point in time.
The one issue, Judge, on that is related to that credit card. Since they've been separated for an extended period of time and he's had use and access to that, we would just ask that anything incurred since the date of separation be earmarked for his separate debt that will need to be resolved again on a final basis, just so the order's clear.
But again, I would suggest that that be reserved as to both, because as you can see from the sealed financial source document, I think it's page 37. The last, she has her own separate card affiliated with this Capital One, and her last Comcast cable charge was $76 on March 12th of 23. So she had separate charges on this card.
Well, there's multiple cards. She's been paying her credit card since separation. He's been paying the Capital One.
The only one that we're talking about in the order at paragraph 8D4 is this Capital One, which is the joint credit card. Her credit cards, she has some separate credit cards, he has some separate credit cards, but this is a joint one where she has continued to charge. And I assume he might have some charges as well. So
I don't think that's accurate, but again, we're resolving the whole divorce on temporary
All right,
basis.
I'm gonna strike paragraph 4 and put reserved.
And Your Honor, I
At
can
this
provide an
point.
update to the court. We were before the court
Okay,
on
thank
April
you.
4th. And I think at that time, it was either a third or fourth review of my motion to compel. And it was subsequently set over to today's date for husband to provide full and complete answers to our discovery request. I received by way of email yesterday afternoon at after 3:30 partial answers to his request. So at this point, what's still outstanding is counsel objected to the business records we requested from 2014 to current. I don't understand the basis of that objection, and he provides no materials relating to the business, both expenses as well as income, but does indicate within his discovery materials that he has a gross income of at least $8,500 a month. So this is an individual that has a successful business. He also indicates that he's a sole proprietor. However, we acknowledge that he in fact works together with the DeRosier company. So it's very vital that we have business records in this case, and we have nothing. My client does not have access to those materials. These parties have been separated since 2016, and the business was created during the marriage. So that's vital. I don't have any income information for 2021. He did present 1099s for 2020 and 2022. I do not have the mortgage from date of separation. He did provide something from 2016, but not from date of separation. I do not have any debts from date of separation. Particularly of concern is that there is at least a $70,000 tax lien on the real property, and we have no information regarding that. So at this point, I mean, the case has been pending since 2016. My original motion was filed and served in October of 22. There's been multiple subsequent orders compelling him to provide discovery. At this point, I'm somewhat frustrated because I think that he provided partial materials just to, again, kick this down the can, and we still need information, and they're still not able to progress this case along to, frankly, even mediation. I mean, these parties haven't even mediated in this case, and we need that information, particularly to the business records. So, I mean, I acknowledge at this point the court is likely not going to default him. However, I would ask for additional fees. My client owes me at least $2,500 for continuing to seek this materials and having numerous reviews. In the meantime, he's paid nothing towards the $5,000 judgment and nothing towards the $500 judgment that the court recently ordered at the last hearing. So I would ask the court for additional fees, set a matter on for a review, and again, just set a drop dead date that there can't be that limits his testimony if he can't provide. But ultimately, the difficulty is I just simply need to know what's the value of this business and what's his overall income for the purposes of fair and equitable division of assets. So that's the relief I'm requesting today.
Right, thank you. Mr. Nagnosti?
Yes, Your Honor. I was out of my office last week, and I contacted counsel and indicated we had the answers ready and asked if she would continue this hearing so we could get the answers to her, and she would not do that. So here we are. The issue before the court is my client answering the interrogatories. He did that. If she has issues with what the answers are, she needs to bring a motion about that. But we, from my point of view, we have fully answered the interrogatories. So we got them to her. The issue of a default should be off. And now the issue is if she doesn't have, I mean, he gave the documents that he could get. We gave them to them. And if there's an issue about those, then we can discuss that in a CR 26I, which is the appropriate next step. And if there's issues beyond that, we come back to before Your Honor. But we answered queries of counsel. I think she now is bringing up fees too, which is not before. The order, I signed off on the proposed order. There was one small change to it. Counsel, I don't know if counsel has agreed to that change in the order or not. She's shaking her head. She's nodding yes. My client gave me the $500 to pay that judgment, and we're prepared to do that. But I just need time since I didn't get back until yesterday to get that accomplished. But he has brought in the $500. I don't know what she's talking about, a $5,000 judgment. I went through the file to look for one and could not find one. But the $500 is paid. It's in my trust account now, and I can make that payment. I just need some time.
Briefly, Your Honor.
Yes.
I just asked the court to look to my underlying motion from October, and it was filed October 25th, 2022. I have correspondence that I attached there dated May 31st, 2022 that clearly outlines the request for production as well as the interrogatories that I was seeking. As I previously presented to the court an update, that hasn't been satisfied. And again, there's been subsequent orders compelling him to provide this information. So the CR26I was already engaged in prior to, so I don't think I have an obligation to continue to engage in CR26Is if that has already been engaged in. So I would ask the court again to set a final date to exchange discovery, consider additional fees, I would note just for the record that that judgment for $5,000 was entered on December 7th, 2022, and it's reflected on this scene.
Yes, that I do see that judgment. Judge Scudder entered December 7th, 2022 on another order to compel. So here's what I'm going to do. I'm not going to impose another $500 today. I'm going to defer it. I'm going to order that all discovery is exchanged no later than the 19th close of business of May. Anything that's not received at that point, I am more than happy to consider limitations as proposed by Ms. Gilmore. And then if we get to that point, then I'll happily reconsider. Again, we did receive a GAL report as requested. Thank you again, Ms. Height. Didn't see it. That was just received last week, I believe, or late the week prior. I see Miss Bliss here. I don't see Mr. Bender. Miss Bliss, any information there?
I don't have any information as to where Mr. Bender is currently. I know that we've had some issues in the past with some hearings and some miscommunications. I did receive the guardian ad litem report. It was going to be my request today to adopt said report, but without him present, that makes it slightly difficult.
Do you want me to set this over, or do you want to note it up after you can reach Mr. Bender?
I think it's probably, so go ahead, Ms. Height.
Excuse me, I did contact his office when I filed this report and made sure that he got a copy. So I know he received a copy.
Okay, thank you.
Your Honor, if we could just set this over maybe 1 week, and then during that time I can chat with Mr. Bender. Maybe we'll have an agreement, and if not, we can bring it back before Your Honor for a decision on that.
We'll set the Jackson & Jackson matter over 1 week to the 9th at 1 p.m. And I guess, Ms. Bliss, if it needs to be reset from there, just let us know, but hopefully we can get taken care of next week. So we do have a GAL report in this case as well. Ms. Height is just killing it this week. I'm assuming everyone, and that was filed last Thursday, everyone's received that and had an opportunity to review that.
We have.
Yes, Your Honor, it was, sorry.
Sorry, Ms. Bliss, go ahead.
Thank you, Mr. Hamir. Your Honor, I did have the opportunity to review the guardian ad litem report with my client. I did receive an email from Mr. Hamir, and I'm not going to speak on your behalf, but it's my understanding that the parties were agreeable to adopting the guardian ad litem recommendations. Obviously, I'll let Mr. Hamir speak for his client. If that is the case, as contained in his email, I'm more than happy to prepare a new parenting plan consistent with those recommendations, and I imagine we can submit those ex parte.
That is correct, Your Honor. The only one request that we are having is that and again, thank you, Ms. Height, for the presentation. The only request that we have is if we can, and if there's no objection, is if my client can complete the required 52-hour domestic violence class through the online Washington State approved court. The reason for that is because he does work and he can work on it. I can work around his work schedule to get that 52-hour week domestic violence course completed, and that's the only request or adoption that we're asking for, or deviation from the report for Ms. Height. Thank you, Your Honor.
Thank you, Mr. Hamir. Ms. Bliss, you want to weigh in on that?
And Your Honor, I frankly don't know, and this might just be ignorance on my part. I didn't know that there was an option to complete it online. I know that we have historically worked with Ms. Lovely, and that's who completed the evaluation, and she recommended the 52-week treatment. I imagine if it's recommended or approved that treatment be completed online, I don't necessarily think that there's an issue. Obviously, so long as the treatment is completed, I'm just ignorant to the fact if it's available online.
Ms. Height, I know in your recommendation, it says her service or another Washington State approved service. So if it's a Washington State approved service and it's online, is there any concern with that?
No, that's fine. I do think that it needs to take that length of time in order for him to do the processing that is usually done in those 52 weeks. So if it's an online thing that, sometimes you can speed those online ones up. And I do think that it's important that it take that time. I think, if you understand what
I do.
Okay.
So I don't have any problem with that language being in there, as long as it is a 52-week domestic violence treatment program and it's approved through Washington State. If online is what works for Mr. Mayfield, I don't have a concern with that.
Thank you, Your Honor.
So if there's no other issues, then I will be happy to
Your
send
Honor,
that
Your
order.
Honor, I do have one other quick issue.
Sure.
My final recommendation, number 10 on page 17, refers to some CPS information that we're still waiting for. I did want the court to know I made an attempt this morning to contact Ms. Bartlett, and as of this moment have not heard anything back. But I do want to just bring that out, that may be an additional issue that comes up down the road.
Okay. And either party have a concern with, I guess, Ms. Height potentially reaching out to you to note it on if anything comes up from that information?
Nothing.
I have no objection with that.
No objection on this side either, Your Honor. Thank you.
All right. Okay, I appreciate Ms. Bliss willing to complete that order, and I will sign it as soon as it's presented.
Your Honor, this matter is on my client's motion to modify the temporary orders. Mr. Hamir, I did receive your email, and my client is wanting to move forward today. So just a heads up on that one. So Your Honor, before the court today is my client, Megan McCain, the moving party, mother of 9-year-old Easton and 7-year-old Ava. As the court is aware, through the lengthy court record, this matter has been pending essentially for the last 10 years since these children were born. There's been several different temporary orders, never a final order. And the parties are, at this point, my client is seeking a parenting plan that essentially mimics what the parties are actually operating under in order to move this forward to a final order. As contained in my client's declaration, the parties have worked diligently between themselves trying to reach some sort of resolution over the last several years. However, that resolution has largely blown up over the last year, given some concerns regarding Mr. Ibarra's substance use, mainly alcohol usage, and exposing the children, these two tender age children, to that substance use, which is provided in my client's declaration and substantiated by his wife, Jacqueline. Those text messages have been provided to the court. What my client is seeking is essentially adopting the status quo. So pursuant to the 2019 parenting plan, Mr. Ibarra is awarded every other weekend visitation and every Monday and Wednesday visitation. My client provides in her declaration that those Monday and Wednesday visits are largely unutilized by Mr. Ibarra, and my client is forced to scramble at the last minute trying to obtain a sitter or some sort of activity for the children, as she can no longer depend on Mr. Ibarra to actually utilize that visitation. So my client is asking for the parenting plan to be slightly modified to just simply remove that Monday and Wednesday visit. She provided calendars for the court that substantiate her claims that they're largely being unutilized. There was, I think, 13 of 14 visits that simply were not utilized by Mr. Ibarra. So we're simply asking that those be removed and that there be a requirement that Mr. Ibarra obtain a substance use evaluation as it relates to alcohol abuse, and that my client be permitted to provide collateral input, namely those text messages from Mr. Ibarra's wife, and obviously her firsthand knowledge of the alcohol use, which is not new, as Your Honor could have seen if you wanted to look back for the last 10 years of pleadings. The substance abuse issue has been raised consistently throughout the course of this case. So that's simply what we're asking before the court today. There's some concerns with, child care and the like. We're simply asking that the temporary orders maintain in place, that Mr. Ibarra and my client both paid a proportionate share of daycare expenses.
All right, thank you, Mr. Hamir.
Thank you, Your Honor. Reviewing the motion, it seems that a lot of the issues and a lot of the allegations are based around the substance abuse issue. My client denies that he has a substance abuse issue. I also think my client also believes that we should be waiting for substance evaluation results. So we are provided with inaccurate information with respect to my client and the allegations of substance abuse. My client does believe that it's prejudicial to him and his rights as a parent in the event that a ruling is made right now without the benefit of a proper substance evaluation. My client is not declining, denying, or stepping away from any type of request for an evaluation or UAs for that matter. I do believe that I did request a 2-week set over to have my client go through a evaluation and a substance abuse and also get UA analysis and bring it forward to the court so we can get a proper analysis with respect to the the parenting plan and so on with matters got to do with that. My client feels that asking for to adapt a status quo based on what has happened now without the benefit of a alcohol evaluation does put him in a situation in where he doesn't feel like he's getting his proper due process. Thank you, Your Honor.
Ms. Bliss?
And Your Honor, I think the record that my client has provided speaks for itself. He simply isn't utilizing the visits that he's currently being provided under the temporary parenting plan. This is a twofold issue, and it seems the council is trying to put them together and say that we shouldn't remove his daytime visitation during the week until we get the substance abuse evaluation. But those are two completely separate issues. One of which is substantiated by his current wife, that he does have an alcohol issue that obviously needs to be addressed. Secondarily, he's got these daytime visits during the week that he's just simply not utilizing. And I have not heard anything from Mr. Ibarra that says that the alcoholism is related to the missed visits. So I don't think that Your Honor should take and wait on one until we get the other back, because they're two completely separate issues. The status quo is every other weekend. That's what what the parties have been operating under, and what Mr. Ibarra has actually utilized. So that's what's in the best interest for these children, is stability.
Here's what I'm going to do. I understand both sides. As far as any 191 factors, I'm not comfortable with the limited information finding any 191 factors at this point in time. So I'm going to reserve on the 191 factors. I am going to order that he have a substance abuse evaluation. It sounds like he's more than willing to do that, and wants to prove that isn't an issue. So that's great. Let's do that. And then I didn't hear a lot of dispute about the proposed schedule, and it does take away some of those daytime visits. I'm gonna adopt the proposed parenting plan if and when we receive that substance abuse evaluation, there's a request to add weekday visits back in. I'm more than happy to consider that. I don't like constantly changing parenting plans, but we are in a temporary space at this point. So
Your Honor.
Mr. Ibarra, you're represented, so I'm gonna ask that you not address me directly unless your attorney is okay with that.
It's okay.
Okay.
Mr. Ibarra, if you've got something to say, you're more than welcome to say it.
Can I say something, Your Honor?
Go ahead.
Okay, so the days that I get, they're at, I got injured in December, so I'm at home in Toledo and I'm half an hour away. So basically I'd have to go, and I said, this just doesn't make sense to go there, pick him up, come back, keep him for half an hour, then take him back another 30 minutes back. And I said that, and I said, is that fine? She didn't say nothing, but I've always picked them up. And when I came there, picked them up for their practices, took them. I even helped her last week when she needs someone to go get them, and I did. So I just don't think that's very fair to me, because
well, there's many other things you could do, Mr. Ibarra, than drive them to and from your home during your visitation time. And I understand that the Pacific Northwest doesn't always have the best weather and to be outside.
okay, I'm just saying it'd be only.
No, I appreciate your comments. I'm not trying to discount them. I understand that. And I would hope that the parties can work on using each other when one party needs help, that dad can step in, or when dad needs help, mom can step in, and that you can work together that way. My hope is this is just a temporary thing until we get that evaluation done, Mr. Ibarra. And my hope would also be that Ms. McCain is willing to consider you if she does need that help again, and can rely on you in those types of situations. But at this point, I'm gonna enter this parenting plan as presented. So that does take away the midweek visits as court ordered. That doesn't mean that you and Ms. McCain can't agree to have a midweek visit or set something up on your own. And then once that evaluation comes back, I'm more than happy to reconsider expanding the visitation during midweek as part of the court order. All right.
Okay.
All right. Thank you, Mr. Ibarra.
Thank you, Judge.
Good luck.
Thank you. Thank you,
All
Counsel.
right.
Thank you.
And this is a contempt. So, Mr. Hunter, go ahead.
Yes, thank you. Good afternoon, Your Honor. So I understand there's a large docket. I'm going to do my best to keep this brief. So we're here on a motion for contempt. The basis for this motion is that on March 10th, the petitioner alleges that there was a violation of Section 14D of the final parenting plan, which that part of the plan states that if mother is to involve the child in the residential schedule, petitioner shall end unsupervised visits, put the concerns in writing with the court immediately, which we've defined as without delay and instant. The respondent has, from the beginning, denied petitioner's allegations. We've notified the petitioner of that on March 22nd and on April 4th, and yet it still took until April 18th for the petitioner to put something in writing, and that was in the first response for our motion for contempt. So the basis for this is pretty simple and straightforward. So contempt is an intentional disobedience of a lawful court order. The court order here is the final parenting plan, and it requires that the petitioner put his concerns in writing immediately. Over a month later is not immediate. And it may seem like a small thing, but there are the reasons that we think that this is an egregious violation. It has to do with the timing. So the petitioner states that he first became aware that their child had a misunderstanding about the residential schedule, and this misunderstanding and the disclosure of it, which is what caused the mental distress, he first learned about this in late February. And he states he did it from a phone call from a school counselor. He then states that the child also brought it to his attention somewhere around February 26th or 27th. It's a little unclear. In which case, he then waited 11 days. And then finally told the respondent of his concerns 1 hour before a scheduled exchange. And now we also point out in Exhibit 5 of our reply declaration that on March 10th, the respondent denied these allegations that she's involving the child in the residential schedule at all, and even offered, is there some way to work forward through all this? And the petitioner stated, no, go to court. That was his reply. The parties must go to court. And a month later, nothing was filed with the court. So that was 2 weekends that respondent missed out on visitation time and was encroaching on her spring break visits as well. This is also disturbing too, because it gives respondent additional time to attempt to seek outside evidence, to cherry pick sources, and then further influence what could be happening. And we think that that's actually what's going on here, Your Honor. I think particularly interesting is the April 17th visit with the child's therapist. And as we point out in our declaration, there's extensive use of passive voice. So the therapist does not say it's the mother telling the child these things, only that child has these ideas about the residential schedule. And that was not the distressing part. That's not the part that distresses the child. The child is distressed when he disclosed it, presumably to the petitioner. And as respondent does state in her journal entries, there's a number of times where the petitioner has yelled at the child and involved the child in conflict. So also interesting to note, the therapist states that their child is a sweet young boy. He's impressionable. He's eager to please both parents. So again, respondent denies that she's ever involved him in these conversations. While it may be true that he has these misunderstandings, they're not coming from respondent. They may be coming from being coached on this. They may be coming from other family members or coming from other parties within petitioner's household, but it's not the respondent. But all of this is beside the point, because the plan requires that these concerns be put in writing with the court. It's not up to the petitioner to unilaterally decide that respondent's in contempt and then fashion a relief. That's not what the plan calls for. And finally, if these mental health concerns are so egregious, the final parenting plan also states that the petitioner is to inform respondent promptly. That didn't happen here either. That was something that he freely admits to in his reply. So there's 2 violations there, just on those 2 issues alone. And there's also some concerning information about air tags being left in clothes going to respondent's house, which could potentially be a 3rd violation by tracking or obtaining information about the other party by using the child. So for those reasons, we're going to ask that father be held in contempt. We ask that the court make a specific finding that the petitioner has violated a residential provision of the parenting plan. We also would request the court to order makeup time for 15 days of missed visits. That's 12 overnights, and there were 3 days of a spring break. And we would also ask for an award of $2,500 in attorney's fees, Your Honor.
2,500, is that what you said?
Yes, Your Honor.
Okay, thank you. Okay, go ahead.
Your Honor, I am wanting to request to set over. Your Honor, there are a number of different factors that are happening with this issue that is before the court. I requested a set over to address those. Since this matter is proceeding and all documents have been filed Is it okay to go forward with both motions as they apply to the whole issue? Respondent did not timely serve me and did not provide me with the signed declaration. This was done in a rushed manner after I spoke with respondent's counsel and indicated I would have the collateral documents supporting my reason for exercising the suspension required in paragraph 14D of our final parenting plan. We also discussed that respondent had proposed a supervised solution, which I agreed with, to which counsel was supposed to get back to me. As we were waiting for documents from the therapist and the school counselor, the respondent's attorney was going to be reviewing the agreement with respondent and would wait for the documents. I understood this was still within reasonable time. Instead, respondent and her attorney rushed to serve me with documents that were not within keeping with the local court rules and tried to limit my ability to present the collateral information to the court. Rather than appear at court for the hearing without a response and requesting a set-over to provide me time to find counsel and respond to documents that were signed under oath, I tried not to inconvenience and delay this matter. However, there were several concerns that had to be raised, which respondent was aware I was planning to present to the court. To address those issues, which directly impact respondent's motion for contempt, as well as her request for makeup time and attorney's fees, required the issues to be heard together. I respectfully request the court set this matter over, or alternatively, that the court hear all matters combined at this hearing. All exhibits and replies have been submitted, and there are no responses due prior to this matter being on next week's docket. Thank you, Your Honor.
So you have all the, anything from the school or counselor has already been submitted?
No, Your Honor.
Okay. So there's a couple different things here, and I did note when Mr. Brock pointed it out that the declaration that was filed on the 6th of April on behalf of Ms. Koski is not signed. There is no signature or date on that declaration, and arguably, well, I think Mr. Brock frankly is correct that could make that something that the court shouldn't consider because it wasn't signed under penalty of perjury. It's likely an oversight by counsel in getting those documents submitted. I do note that we're on next week for the 9th on this matter. I am concerned that there's been no visitation for an extended period of time, and I do understand mom's concerns in this case. I'm talking. But frankly, I will set this over 1 week and we'll handle it all on the 9th. I do note that the counter for relief motion that Mr. Brock filed is on for the 9th. So let's handle these both at once. If there's any additional information regarding mental health or concerns from school for the child, then I ask that be filed as soon as possible and obviously shared with the other side. If they're, because obviously my concern first and foremost is for the child, but I also feel very strongly that both parents should have visitation and access to the child, and so I don't want to delay that any longer than it already has been. So I'm going to set this over to the 9th at 1 o'clock. We'll handle the counter motion and the contempt at that point in time. So that'll be my decision for today.
All right.
If there's anything that needs to be filed late, send it to Superior Court Administration email, and I'll make sure to review it. And I'll just put a note in the file. So I'll allow late submissions because I understand things from counselors and schools sometimes don't get returned in a timely fashion. So if either side has any of that information, just make sure it gets emailed to Superior Court Administration. They'll get it to me, and I'll review it before next Tuesday afternoon.
Understood. Your Honor, I'll just point out that Ms. Koski's signed declaration has been filed.
Okay, I didn't see it in Odyssey, so I appreciate that being remedied.
Yes, so it is there, and we have one letter from the counselor has been submitted today, and that should be everything for us.
Okay. All right. Thank you both. We'll see you next Tuesday at 1 p.m.
Thank you, Your Honor.
Are we allowed? Sorry, Your Honor.
No, it's okay.
Can we still allow additional information that is new?
If it's regarding the child's mental health and well-being, yes.
Okay, thank you, Your Honor.
All right. Sure. I'm gonna start on this one. So again, Ms. Height, thank you. We have a current plan that's week on, week off for the younger two, with the older child on weekends. And I know both sides have their positions. I know that I guess in reviewing the guardian ad litem report, each child kind of had a different opinion about what they wanted to have happen in here. And I don't, that's not the only factor, obviously. But in keeping with what the kids were kind of requesting, it sort of to me looked like the current plan is workable. And I know that Ms. Height suggested that the eldest son should be kind of put back into the loop with the other kids and have that be the same. His request is a little bit different than that. But he also is concerned with weekends. Sounds like he plays some sports and is involved in some activities. And so the weekends may not always be the best thing. So I guess what's everybody's thoughts here based on this most recent GAL report?
I can start with my motion. I mean, I can make my argument. Obviously, the court's received the materials. I think that what our concern is that not just the concern is that waiting until trial to have this issue resolved. Is I think that mother's statements continue to deteriorate the relationship between the children. I think that rather than kind of addressing, the concerns the court and the GAL had, she rather went on the attack and kind of has continued to villainize this child to the other children. I think that we pointed out in our declarations that she's making statements that this child is homophobic and is abusive. And I think that, frankly, her declaration is concerning for the fact that it seems that she's supporting conflict between the three children. Particularly, she's, again, seems pleased by the fact that the younger child punched Dale in the face for finally picking back. I just don't think that that's appropriate. And so I acknowledge the court's position, but I do think that the current guardian report's in the best interest of the children. And I am concerned that if these children continue to be divided, then that divide will only grow. Dale isn't the oldest child. There's two older children and they're twins. And so I think that relationship is particularly unique in the fact that again, they were born on the same day, and typically that suggests that those relationships are close. So I appreciate the court's commentary that, maybe we just keep the schedule the same in hopes of either reaching an agreement or taking this case to trial. But just knowing both of attorneys' schedules and the court's calendar, this case isn't going to go to trial probably until late summer, fall, if not beyond that. And again, my client does have concerns that as the children remain in a 50-50 situation, or the two other children remain in a 50-50 situation, that their relationship with their brother will be forever damaged. And in the meantime, the Dale's mental health continues to decline because he feels like he's being ostracized by his mother based on her statements and actions. So that is the concern and my response back to that.
Thank you, Ms. Gilmore. Ms. McLean.
I guess my immediate response to Ms. Gilmore's comment is, she talks about Dale's deteriorating mental health, and yet they don't produce any documentation of Dale's mental health records. There's no indication that Ms. Height talked to any of these children's counselors. The suggestion that, Dale has the right to not give my client the option to have access to those or to be involved. Dad's clearly involved, so why hasn't Dad provided that information? There's clearly our perception is that clearly Mr. Bartow is using this situation that occurred with Adrian last year, this singular incident, as a means to step in and try and take a custody grab hold in this circumstance. And one, we don't think that that's appropriate. Two, when you look at the mental health records, look specifically at what the Emma and Alexander have told their counselors. Ms. Gilmore, her client, has not been present during those counseling, not during all of those counseling sessions. Both of these parents, when they have been present, have provided input to the counselor. My understanding is that input to the counselor is not while the children are present, that the parents usually provide that information ahead of time in a separate session. The counselor meets with the children then provide their information. And again, that would be information that Ms. Height might be able to ferret out by having a conversation with these counselors. But clearly, Alexander's secondary diagnosis is sibling relationship issues, and that's directly with his relationship with Dale. Dale is a bully. You can see it in his school records with third parties, with teachers, with bus drivers, with other children, with his siblings, with his mother, with Adrian. All of that is whatever's driving this kid. But the fact that it's affecting Alexander is concerning. And he describes that, and that's identified as a secondary diagnosis for him. So the suggestion of putting him in more contact with Dale is not the appropriate solution here, because again, as my client asked Ms. Height to please interview the kids separately because of the concern about the overbearing nature. And with these younger two, and I'm going to refer to Emma as younger because it's my understanding Dale was the first twin born. These younger two basically kowtow to him. So when they're in a room together, he's the dominant individual or the dominant sibling. Go to Emma's counseling records. Emma tells the counselor her strongest relationship is with her mother and her younger brother. It's Emma who tells her counselor that she is bisexual and that Dale is homophobic and he uses homophobic slurs against her at school. He calls her names at school. My client isn't there. Mr. Bartow isn't there at school. He's doing these things to his siblings as well as to other children at school. So the suggestion that we need to put them with more time with this sibling who has issues that are not appropriately being addressed. There's been no discussion about doing joint counseling with my client as Dr. Tolby had recommended. My client has made an effort. Mr. Bartow has not supported that effort. Mr. Bartow has supported Dale's effort to essentially isolate from mom and to project this incident that occurred in December much further than what it was. I mean, Mr. Bartow's most recent declaration again refers to Adrian's interaction as punching Dale. Go back and look at, again, the children's information to their own counselors at the time was that Adrian backhanded him because he was being disrespectful and he called Emma a pig while they were having this family discussion. And he was just being totally inappropriate. Backhanded him, and there's no information by these children to their counselors that Dale was thrown to the floor or pushed to the floor or that he was punched and it put him off of the couch. That's what you see when there's other testimony and these declarations is just this confabulation of a story that Mr. Bartow is trying to explode to cause a suggestion that there is this dissension. And while there is dissension, quite frankly, my client tells you it's her belief and her counselor's belief that Dale has ODD. Of course, we don't have the counseling records because they won't provide them. I suppose I could subpoena them. But again, that's information that we should have had through this guardian ad litem investigation to figure out what's going on. My client was unaware when she went into the appointment with Dr. Tolby that this was to remove him from medication. You go back and look, the suggestion is, well, Mr. Bartow says he doesn't want to take his medication. Well, prior, when there were counselors, the child's counselor and teachers involved in the process, it was all determined by those third-party people that interact with Dale that he needed to be on medication. But we have this temporary custody change, and all of a sudden he comes off of the medication. We have my client being removed as an involved parent on his medical information. She can't even access information because she's been removed from that. Again, this is
for just Dale or for
just Dale. Well, originally, I believe she was removed also from Emma, but she got back on to Emma's because she didn't switch providers. Mr. Bartow was trying to encourage Emma to switch providers from Columbia Wellness to Core Health, which is where Dale is apparently attending Core Health, and they meet with him apparently at school. They pull him out of school, where Emma actually goes into Columbia Wellness for appointments, is my understanding. So there is real dissension between these children. There was absolutely no support by my client about these boys engaging physically or verbally. She feels like she's put in a position where she's under a microscope. If she does anything to discipline, and if somebody from the backside receives a story from one of these kids, then she's going to be, either criminally charged, or she just feels like she's in a position where she cannot appropriately discipline her children because of this circumstance. It's empowered Dale to react and behave inappropriately because the court has arguably removed him on the week from the joint custody. But on the other hand, it's been a positive thing for these younger kids because look at their grades. Their grades are doing great. Dale's grades have declined. If you look at Emma's first term and second term, she's consistent A's and B's. Dale was A's and B's, and now he sees B's and C's and a D. If you go back and look at his second term grades, he has declined. And again, we don't have any counseling records for him, so I can't speak to the suggestion by Ms. Gilmore as far as how he's doing emotionally. But you can see specifically that these other two children both vocalize having interrelationship problems with Dale, that Dale bullies them both within households and within school, that Dale calls them inappropriate names. And right now, having only to be with him on, I guess, on the week that they're with dad, is better than having to be with him a full, pretty much every day. And they still see each other at school. Quite frankly, our position is that you leave Dale with dad primarily, leave the other two primarily with mom, and have them be together on weekends. So every other weekend, all three kids would be at dad's, the next weekend with mom, the next weekend with dad, to allow them to have sort of that downtime during the week away from each other, and to allow for them to have that more structured time on the weekends when they're not having to worry about school and everything else. And Emma and Dale will still see each other at school, even though we have difficulties with him in that school setting. And then Alexander would see him on the weekends. So that would be our position. If there's any changes to be made, we think that would be the position to be made. You saw in my client's declaration, I mean, we've got a third-party mother who's reached out to her because Dale's bullied her daughter.
Well, I judged my client's declaration. There was zero reference of who this individual was. It was clearly an out-of-court statement, and it didn't even look like the conversation was happening between the mother, this unknown individual, and client. It was in some sort of third-party sense. So I objected to that in my declaration. So
it was the mother and her daughter's communication, and she reached out to my client because Dale was being inappropriate and how he was rejecting these girls.
I'm not going to consider that. I know so if you have anything else, Ms. McLean.
I guess the other thing that I just assumed that you went back and read through the sealed health documentation on the on the children's mental health records. While I understand, and it is clear, it should be clear, my client is not involved in a relationship with Adrian. They are not in a dating relationship. My client proposes adding language to the parenting plan that any future individuals would be disclosed to the father, and he'd have an opportunity to do those background checks and the like before there were any disclosure of that of a future individual to the children. On the other hand, if you go back and look at the children's information to their counselors, they both saw the ending of that relationship with Adrian as a negative. They both saw him as a positive role model. They saw him as someone sort of, I guess, for lack of a better word, sort of as an equalizer in being a role model in appropriate behavior, and tempering some of Dale's behaviors. And they talked glowingly about Adrian to the counselor, which again is completely different than how he's been portrayed, or essentially backhanding Dale for calling Emma a pig during a family conversation. So be it right or wrong, the fact is that the children saw this as a positive relationship. They saw it as a loss because of that abrupt ending. But my client is not in a relationship with this individual. She is taking the court's orders seriously. And she wants to make sure that all of her children are emotionally healthy. And for these younger two, that is to reduce the time where they can be negatively influenced by Dale. And she's not demonizing Dale. Children behave differently. Clearly, Dale has some different ideas. He does not respect Alexander's sexuality. He does not respect Emma's sexuality. He's derogatory and negative in that. And this is a tender time for all of these children. You have Emma, when you go back and look through those counseling records, she's isolating and withdrawing because of his behaviors. She's having to second question. And I mean, already teen girls in particular suffer a lot of depression just because of social stigma and the information that's out there. And to have a brother that's telling you that you're a pig and she's concerned about what she should.
I understand the argument. I think that it's been presented multiple times, but at this point, this is a 15-year-old child. This is a public hearing that's subject to YouTube. This is a minor. So I think that, I mean, again, I think that the point has been made cross, but I think that if any of these children have access to these materials, I mean, I just think it's completely inappropriate. These are between the parents. If there's issues between the parents, those should be made. But to completely malign a 15-year-old's character, including naming him homophobic, despite the GL not making any such findings, I don't think it's appropriate to make in a public hearing.
I understand the sensitive nature of this, and it. I think I understand where Ms. McLean's going. So if you go ahead, Ms. McLean.
That's fine. I guess my concern is you still have a child in Emma who is still suffering from depression, even though being removed from him because of things that are still occurring. And to put her full-time with him and remove her from the caregiver with whom she identifies as her strongest connection and her sibling with whom she identifies as her stronger connection, that being Alexander, I think is setting this young lady up for failure. As well as Alexander.
I limited my argument because I thought that we were going in the direction of the court making a short ruling, but if I can provide additional commentary, I'd appreciate it. Or if you want to hear from the guardian first, I understand.
No, go ahead, Ms. Gilmore.
I think first, just addressing the Godby issue, my client presented it in his declaration. He 100% doesn't believe that she has ended this relationship. He even testified, contrary to her statements, that they only ended the relationship a month ago. So we really believe the entire basis of this kind of tirade against Dale is that mother's mad that she is forced to either not live with her boyfriend or pretend to break up with him because he assaulted the child. I think it's important to acknowledge and look back to the records. Is the fact is that the children didn't have a long established relationship with this individual. They had known each other for 7 months and had lived together for 2 weeks prior to the assault on the child. The court should look back to the records that this individual has RCW 191 findings against him for his own child, for domestic violence, for child abuse, for substance abuse. He's been convicted of a litany of both felonies and misdemeanors for domestic violence. So if the children have some sort of well-established relationship, it's based on the manipulation of mother, not actual fact in this case. And so I think that, again, I've just never frankly had a case where a parent presumes to, again, blame and malign a child's character. And again, I think that it's clear in both counsel's argument as well as mother's declaration that her mindset hasn't changed and she's going to continue to go on this tirade. If the court looks at the exhibits in support of mother's position, there are statements that from records, school records from back in 2019, 2020, and 2021, where there are minor offenses for Dale that were to the point where the teacher didn't even call a parent. So all of these records are extremely old and minor. My client explains to you that none of these issues happen in his home. The children don't fight, they get along, there's no name calling, and they're able to have a bonded relationship at his home. He testifies, and it's undisputed that none of these things happen in his home, and it's solely mother's home because she pits one child against another. If the court looks to the mental health records, I think that it's very clear that the conversations are happening simultaneously. Mother makes statements, i.e. Dale's homophobic, and then child makes statements that he's uncomfortable with his brother's behavior because mom is asserting that behavior is inappropriate. Turning to my client, or excuse me, the child's mental health records, the child is 15 years old. The court is very aware of Washington state statute that he has a right to have that information be private. And he did sign a release of information to the guardian ad litem. So she has access to those records. If she, I'm assuming she's reviewed those. I don't know. But I believe that was a part of her consideration when coming to the recommendation that all children should be together at my client's home and have alternating weekends with mother. The issues in mother's home, my client's visitation with the other two children shouldn't be limited based on this new request that the other two children should have weekend visitation with him. The children need to build their relationship, not further separate it. And again, I think that the guardian ad litem did a full investigation and it was clear that that mother should have alternating weekends. I think that, again, it's only going to further damage the children's relationship with both their parents and each other and society at large. Because of these very frankly odd statements that mom and position mom's taking against this minor child. He is not a monster. I don't know how else to say it. So thank you.
Thank you, Ms. Gilmore. Ms. Height, do you want to add anything to the mix?
I would, Your Honor. Thank you. I guess I'd like to clarify for you. I'd like to describe the visit that I had with the children, perhaps far-reaching enough in my description of that. We met, when I write, we met at a fast food outlet. It sounds like it could have been a chaotic, noisy public place. It was not. We met late afternoon at the Kelso Taco Time, which has a large dining area that was essentially, I believe the entire hour or hour and a half that we were there was empty except for our little group. I don't recall anyone else being there, and we were way over in a corner. We had a lot of privacy and it was quiet there. During my visit with those kids, there was a period of time in which Dale got up and went to the bathroom and walked around for a while and came back. So there was some time of privacy or separateness between him and the other kids. But as I recall that visit, Your Honor, the kids they seemed to be on an equal footing emotionally. They interacted well. They were witty together. There was some back and forth humor. There were some serious, very serious topics that were discussed. There was a level of respect between them in that when one talked, everybody else was quiet. There were times then of being interrupted, and the one who was being interrupted clearly said, "Wait, it's my turn," and whoever was interrupting stopped. And that was bilateral. That wasn't one child who was constantly overriding the others. There was, and I understood the problem going into this, and so I frankly expected there to be a more one-sided conversation during part of it, and I was prepared to divide the children more if need be. But there was definitely an equality between those kids and a normal, what seemed like a normal sibling back and forth and friendliness. So I wanted to make that seem clear to your honor, because it may have seemed like it was not a thorough or well thought out place. I felt like having my conversation with them at a neutral site was in their best interest, and it turned out to be a very forthcoming and helpful conversation. Which brings me to, I guess, I wonder at this point, hearing what I'm hearing today, I'm wondering if we have a sibling problem or we have a parenting problem. Because in discussing these kids with Dad, there really wasn't a report of the kind of animosity that I'm hearing about otherwise. And then I guess in closing, I would say, Your Honor, that I really value sibling relationships. I think it's important for those kids to have quality time together. And what I saw them doing, how I saw them behaving and interacting during my visit with them was heartening. They were frankly delightful children. I enjoyed them each very much. I could see that they're each very different. They each have strong opinions, but nobody seemed to be under the thumb of anyone else. No one seemed to be fearful to speak out in front of the others or fearful to speak out to me. So I hope that's clarifying and doesn't just make your task more difficult, Your Honor. I wanted to clarify that.
I appreciate that. Thank you. And I think one of the things Ms. Height said is kind of, frankly, been what I've been debating since I started reviewing the documents in this case and the report and motion by Ms. Gilmore in response. It does appear there is some kind of a vilifying of one of these children, and there may be concerns, there may be issues, but one child isn't the result of what we're dealing with right now. I can't believe that. There's two parents that clearly want to be involved, want to be around and parent their children, and one child is having some difficulties. I would hope that there would be a bolstering of support from parents. And frankly, some of the comments in the responsive declaration from Ms. Cadwell were concerning. I mean, I don't know that I could go so far as to say she's throwing the elder twin under the bus, but it really kind of came across that way. And the concern, regardless of how extreme the situation in November or December was. Hitting a child is not okay, let alone somebody that's not a parent that has only been in the child's life for days to hit a child. That's not okay. So I don't know if I'm going to give mom benefit of the doubt that this isn't retaliatory against a child for a reaction to being slapped, hit, backhanded, punched, whatever happened by a non-parent that he'd known for a week or two. That's pretty reasonable for a child to be upset by that. And clearly in the mental health records, it impacted the other kids pretty significantly to see that, watch that, have that happen to their brother clearly not being appropriate to siblings, doesn't deserve to get hit in the face, period. I came into this thinking I'm going to just leave. The most recent parenting plan was entered at the end of December. My initial thoughts were I'm leaving that where we're at. The more I hear the supplemental information from Ms. Height, I don't like the trend I'm seeing. If we have a child that's having an issue, is having some issues, understanding, being appropriate to siblings about their potential sexuality or beliefs in the kind of people they are, then parents need to step in and try to educate, help, counsel that child, not cast them out as the problem in everything else that's going on. So I'm going to grant Ms. Gilmore's request. I'm going to adopt the recommendations of Ms. Height. I think it's appropriate to try to integrate these children back together to see if they can build on a relationship and let the parents parent and figure out how to get them working together and address some of the issues that they may be having as siblings. You didn't submit a proposed order. Okay, so I'll sign that. We can either set it for presentation if there's things you need to work out with Ms. McLean, or we can do it ex parte. Do the council have a preference?
Let's set it on for presentation.
Do you want to do that on a Friday or a Tuesday? And how much time do you need?
My preference is a Tuesday.
I can do a Tuesday. That being said, I do have trial the week of the 16th, so I can either do a quick turnaround on the 9th or the 23rd.
Right now I have I have 5 matters on the 9th. Could we go to the 23rd?
That's fine. If we're pushing out that far, I just need direction on the court on when we want to start implementing this.
Where are we? Let's do Friday afternoon, because it seems like that was always an exchange. Is that correct?
Yes.
So let's do Friday the 5th to start. And then if it's mom's weekend, whomever's normal weekend it would be. I don't want to change everything too much unless, it's so whoever's weekend's upcoming should keep that, and then we'll go from there.
Okay.
Your Honor, I would also just note that Mother's Day is coming up, and it would certainly be appropriate for them to have time with mom.
So if the 14th is Mother's Day, I believe. If that is an off weekend for mom should be able to have the kids that day for an extended period of time.
I believe that we have a holiday schedule. I'll have to look back, but I can coordinate. I understand the court's doing.
And then is the court going to consider a midweek visit since we've gone from a joint custody?
Mother's Day is factored in to the previous schedule, so she's already 10 a.m. to 6 p.m. according to that. So I'd want that, and Father's Day is factored in. It looks like Mother's Day, Father's Day, 4th of July, Thanksgiving, and Christmas is already factored in. So if there's no concerns with those, just keeping those as previously ordered. Ms. Gilmore, any midweek?
I messaged my client trying to get an opinion or.
I'm not opposed to a midweek, like a Wednesday after school till 6 or 7, 8, something like that. If the parties want to come up with some proposals. And if you can agree, great. If not, we can discuss that on the 23rd, but I'm not opposed to a midweek visit. And if it,
And I guess my suggestion would be that if we're moving away from the joint custody as it relates to the other two, then at least should be Friday to Monday, pick up after school, deliver to school, and then because they've been doing that, and then Wednesday to Thursday. And then obviously summer's going to be coming around in 6 weeks. So I propose going back to the week on, week off during the summer.
I believe Ms. Height's recommendation was 50-50 in the summer. So I would agree with that.
It says school week. Oh, it does say summer.
So yes, so this is only going to really impact them for maybe a month before they're back to essentially a 50-50 schedule for the summertime. I don't want to complicate this more than I already have, but if there's different activities for different kids that make different weeknights better for each child to be with mom, I'm not opposed to that as well. I don't think the weeknight visits necessarily has to be all three at the same time. So if it's, if it works better, 2 kids on this night and 1 kid on this night, or, if the parties can work that out. Otherwise, I'm happy to hear a couple of proposals on the 23rd.
And my client indicated he's fine with 2 to 6 on Wednesday. I would just ask, I didn't provide commentary, but I would just ask that the schedule is the same as Dale's, which is Friday to Sunday. I think it would complicate it significantly if the other children went to Monday. So I just ask that it's consistent with Dale's schedule from Friday to Sunday.
And I think we just do all 3 kids the same from Friday after school to Monday at school.
I'm going to do that Friday at school to Monday morning at school.
Well, and to further complicate things, Your Honor, I apologize. My recommendation as far as vacations went was speaking of the Christmas and spring break vacations. And I was recommending 2 weeks of uninterrupted time with mother during the summer, unless the parties wanted to have more. So that's significantly different than 50-50. So just to throw that rock in the pond.
I'm sorry. I thought I read 50-50 summer. Let me,
You did. The vacation was for, like I say, it was for those shorter school time vacations. I was not very specific on that. I apologize, Your Honor.
All right.
And I would just argue that I think it's appropriate for the week on, week out, or even do a 2 week on, 2 week off during the summer to allow them for extended holidays or extended vacation.
Well, I think that my same argument applies for the residential schedule as the summer schedule. If the court has concerns to the point that they're needing transfer custody to one parent, I have concerns that, again, then we immediately expose the kids to the same behaviors in the summer. So I just ask that the court just provide that additional, 2 weeks of summer vacation to the mother, and then they continue the schedule so that we can, at least the children can get set in their place. And if it works, then we know, and we can hopefully get this case resolved. If it doesn't, then we can get it to trial before the fall.
Do we have a trial date scheduled?
No. No, we have to update discovery, and I can tell the court I already have a 3-day trial in September. I have a 3-day trial in October. Realistically, we're looking at late winter for me.
Okay.
Your Honor, what I liked about having just the 2 weeks was I did add, if you note in recommendation number 4, that if it was agreeable that the kids wanted to have more time with mom, at that point, that could be done on an individual basis. If one of the kids wanted to go more often, that would give them that option. So it gave them a little more say-so than having it all legislated out throughout the whole summer. That was my thinking on that. So.
All right, I appreciate that. Here's what I'm going to do. I'm going to, and in reading it again, it does say school vacations, it's summer break. And then, so it defines it differently. I read it just kind of thinking vacation from school. So summer's going to be the same as the rest of the year. I'm going to allow two different 2-week terms. So a total of 4 weeks in the summer, uninterrupted with each parent. And those dates need to be to each other by, we're kind of late now. So let's say, well, let's have them those dates by when we come back on the 23rd. Each parent will get 4 weeks total, 2 weeks at a time. throughout
And
the summer.
I guess the only thing that I would point out is there's essentially 10 weeks for a summer. So I think it would just be easier if you did week on, week off, and then that way we don't have to decide whose weeks are going to be what. But I understand.
That's my ruling. If parties, if it becomes difficult and
Sure.
you agree to a week on, week off in the summer, because that'll be easier, or a 2 week on, week on, week off, 2 week on situation, I'm okay with that. But as of right now, I'm going to say that each party gets 2 weeks in 2 weeks uninterrupted.
All right.
We can't schedule that, then I'll make a decision on the 23rd.
All right. Okay. Thank you.
All right. Thank you all. Good luck.